Hello, a couple of interesting cases in this Bulletin 41 that I'll just briefly mention. The first is the estate of Linworth. In that case, there was an argument about whether the person had capacity, but a caveat was lodged which was the wrong form of caveat, and there was some discussion about that and the implications. In the event, the matter was proceeded on the basis that there was a doubt about the person's capacity, and therefore the caveat wasn't removed. But just good to note what was said about caveats and the right caveat to file in these matters. So that was regarding a proof of a will in solemn form, and some remarks about the form of caveat only enabling the matter to be determined on the formalities, or to determine whether the formalities have been complied with. Anyway, I'll leave the summary for you to look at. The other one was a family provision claim, Rathwell and Court. An interesting case because the applicant had a history of drug abuse and was suffering depression, basically had nothing, I think $11,000 only, and his sister, who moved in to look after their father in 2017 and had determined to keep her siblings away from her father. She actually received $100,000 from her father's account, so she was actually in good shape. The brother in the end received $500,000, sufficient for him to have a roof over his head, but because of his history of drug abuse, it was being looked after or ordered to be dealt with through a trust. Just a sensible, you would say, outcome, but interesting just observations on what the court's view of people who act in such a way as to keep others away from their parents. Everything seems to come out in these family provision cases, so it's best to realise that and accept that, and hopefully be on the right side when these arguments arise. Thank you.